Good afternoon, ladies and gentlemen. I'm your lecturer. I'll be taking you on the subject labor law. We are starting with strike and the law, procedure for the settlement of industrial disputes. My name is Timothy Abiodun Olatukubo Tubiyele. I'm a legal practitioner. I was called to the Nigerian bar in 1980. I've had the opportunity to practice law, teach law, and write and edit law books. I had the opportunity to teach at the Nigerian Law School, and I've written many books, and I have a book on labor laws. I've also had the privilege and the opportunity of presenting lectures on the subject of labor laws. I will be introducing the book on labor law to you in the course of this lecture. The book on labor law that I've authored. But meanwhile, I will be taking you on this subject, which I've had the opportunity of conducting at many seminars as far back as 1986. We see here strikes in Nigeria. There should be no strike under the laws in this country. But one finds that under the relationship of master-servant, employer-employee relationship, the servant uses strikes to make or coerce the employee to agree to certain terms of conditions of employment of the servant employee. The employer is coerced. I use the word coerced because the effects of strike has that power to force. The employer of labor too employs strikes. To use the same word also, to coerce or force the servant employee to agree to certain terms and conditions of service. Strikes and lockouts are illegal under Nigerian laws. I must read out to you the definition of strikes. You must look at Section 48, Subsection 1, Trade Disputes Act, Laws of Federation, Cap T 8 of the year 2004. Strike means the cessation of work by a body of persons employed acting in combination or a concerted refusal or a refusal under a common understanding of any number of persons employed to continue to work for an employer in consequence of a dispute, done as a means of compelling the employer or any person or body of persons employed to accept terms of employment and physical conditions of work. And in this definition, you can go on and look at that law yourself. It defines cessation of work. If cessation of work includes working at less than usual speed or with usual efficiency. Refusal to work includes a refusal to work at usual speed or with usual efficiency. What must we take into consideration when we look at the definition of strikes under Nigerian law? There must be a dispute. I will go on to define dispute. That means a dispute in a broad interpretation without going to the specific definition. It must be connected to the terms and condition of employment of the servant. What do we find in present-day Nigeria? In the year 2021, a union of junior staff in the judiciary, popularly known as JUSU, they went on a strike. They paralyzed the court system in Nigeria for almost 3 months. What was the purpose of their quote and unquote strike? They were asking for judicial autonomy. What has judicial autonomy got to do with the condition of employment of the employee? That is my own view. This is a question I would like us to ponder about. And the judiciary, the third arm of government in Nigeria, was paralyzed for 3 months. So let us continue to ponder on this when I go on with my lecture. Definition of lockout. Lockout means the closing of a place of employment or the suspension of work or the refusal of an employer to continue to work any number of persons, to employ any number of persons employed by him in consequence of a dispute, done with a view to compelling those persons or to aid another employer in compelling persons employed by him to accept terms of employment and physical conditions of work. Lockouts are not very common in present-day Nigeria, but it cannot be ruled out. Let's look at the definition of trade dispute. In the definition of strike, it talked about dispute. The dispute we are talking about is trade dispute, not political dispute. Trade dispute means any dispute between the employers and the workers, or between workers and workers, which is connected with the employment or non-employment or the terms of employment and physical conditions of work of any persons. A claim for wrongful dismissal is not a trade dispute. Look at Section 48 Trade Dispute Act, Laws of Federation, 2004. Then you can also look at some cases. Sea Trucks Nigeria Limited versus Payne, 1995, 6 Nigerian Weekly Law Report, Part 400, page 166, particularly at page 180. It's a Court of Appeal case. Tidex Nigeria Limited versus New Pen, 1998, 11 Nigerian Weekly Law Report, page 263 at page 277. Olorutoba Oju versus Dopamu, 2003 Federation Weekly Law Report, Part 158, page 1268, particularly at page 1284. An action in furtherance of a private animosity was held not to be a trade dispute in the case of Conway versus Wade, 1990 Appeal Cases, page 406. So we are beginning to see the picture now. Let us look at the first definition of strike. Let us look at the definition of trade dispute. Much of what unions go on quote and unquote strikes upon in Nigeria does not legally qualify as a strike. For example, we find the trade unions threatening and actually going on strike whenever there's increase in the price of fuel. What has increased in the price of fuel got to do with the physical or condition of employment of somebody who is working perhaps in the civil service? I want you to continue to ponder on this. Meaning of intra-union dispute. Intra-union dispute. Intra means within, while dispute means to make a subject of argument, to contend for, to oppose by argument, to call into question, to argue, to debate. Therefore, intra-union dispute is an argument of or dispute within a union. Let us look at Section 25, Trade Dispute Act. It is a dispute arising from the organization and running of the trade union as laid down by the union's constitution. An intra-union dispute or a dispute within the trade union cannot be a trade dispute as defined by Section 48 of the Trade Dispute Act. Look at the case of Daniel versus Fadugba. 1998 13 Nigerian Weekly Law Report, Part 582, page 482, at page 496. It's a Court of Appeal decision. Who has the jurisdiction to hear inter or intra-union dispute within the meaning of Section 1A of the Decree number 42 of 1982. The mischief arrived at by the amendment of the decree is to avoid the proliferation of trade union cases in several high courts and ensure litigation in the National Industrial Court only. There are so many cases: Ekong versus Uside, Court of Appeal; NURTW versus Ugbolo, 1998, 2 Nigerian Weekly Law Report; Udo versus HMBH. Those are cases you can look up and read. Strikes and lockouts are still a common occurrence in present-day Nigeria, although it is illegal. And solutions to the trade dispute by the roundtable method has been prescribed by law. Then why are we still having strikes? I remember in the year 2021 when the courts were shut by what I call an illegal strike. I made my views known and many people opposed me vehemently. So it's an observation that strikes and lockouts are still a common occurrence in present-day Nigeria, although it is illegal, and solutions to trade dispute by the round table has been prescribed by law. I repeat. Let's look at Section 18, subsection 1, 2, 3, and 4, and 1, 2, and 3 of the Trade Dispute Act 2004. I will urge you to look at these various sections. It provides for steps to be taken in the settlement of industrial dispute. If there's an agreed method for the settlement of industrial dispute, one, that must be resorted to. How do we do that? Usually in collective agreements between the employer and the employee. How do we resolve a dispute? First, go to the collective agreement between the employer and the employee. If solution cannot be found out, then a report can be made to the Minister of Labor. A conciliator will be appointed. Should that fail, the matter is referred to the Industrial Arbitration Panel. And the final port of call is the National Industrial Court. And if you do not follow this procedure, as many of our unions do not follow this procedure, there are penalties. Let us look at subsection 2 of the section that I referred you to. Any person who contravenes subsection 1 of this section shall be guilty of an offense and be liable on conviction. A, in the case of an individual, to a fine of 100 naira, or to imprisonment for 6 months. In the case of a body corporate, to a fine of 1,000 naira. The penalty for breaching the law, I submit, is not such that will deter people from breaching the law. Somebody who leads a strike presents himself as a hero to the workers, and if he's taken to court, he can be fined for as little as 100 naira. Is that a deterrent? There was a day I was discussing with a trade union leader, and he was boasting to me. He shut down the ports, and I was shut down the ports. I suggested to him if he can get me to organize a seminar for them, because he's a member, he's a union leader. I tried, but after some time, I had to give up. I have organized or I've facilitated in so many seminars for trade union members. Sometimes organizations bring their members to attend some seminars I facilitate. With due respect to trade union leaders, I discovered it's very hard for them to impart new knowledge. There is this spirit of aggression in most unionists. All they think about is strike, forcing the employer to do something according to their wish. And it's not like that. There are procedures for the settlement of industrial dispute. And if you do not follow these procedures, there are penalties for it. Even if it's 100 naira that you are fined, it's in your record that you have been convicted and fined 100 naira. You are an ex-convict. And if you go to prison for organizing or participating in a strike, it's in your record. 6 months makes you an ex-convict. And there are offices, political offices, even in business, you cannot be the director of a company as an ex-convict. We should begin to think about these things. There are penalties for going on strike. So when these penalties are there, we should know that strikes is not permitted according to the laws in Nigeria. The legal position, I conclude, is that at no point and no circumstances can workers or employers employ strikes and employees lock out as a weapon of coercion against the opponent. The worker has therefore apparently lost forever, at least until the law is amended, the right to strike. I think I will love to end the lecture here. I still have so much to teach you. In the next lecture, I will be teaching about the legitimacy of strikes. Can strikes be legitimate? Look forward to listening to my next lecture. If you want to have a deep grasp of labor laws and practice in Nigeria, you must have this book, which I authored. Labor Laws and Practice by T.A.O. Chubiri. Look for this book. It will help you to have a proper grasp of labor laws in Nigeria. You are a lawyer. You will be able to advise your clients on labor matters. You are in the human resources. You need this book to be able to have a grasp of labor law in Nigeria. You are a student. And even my lords, judges and justices, we must have a grasp of labor laws in Nigeria. I thank you for listening to me. I have taken some of your time. It is to educate you. Strikes and lockouts are illegal in Nigeria.